First of all, can everybody hear me? If you can hear me, you can just raise your hand or type in the chat. Anybody? Nobody? Okay, great. So I'll be going according to the course outline. So I'm going to start with the nations, the scope of international law, the nature and scope of international law. I'll be taking the questions like right after each topic or each, I'll be taking the questions right after each topic, so you can either raise your hand for the questions or you can put them in the chat. So first of all, what is international law? And so international law, it basically governs the relationship between independent states. And it is a body of rules and principles of actions which are binding on states in their relations to one another. And you have private and public international law. So you might have the question of like, what is the importance of international law? Basically, international law is important because, as the definition says, it basically guides the relationship between states. So without these set of rules and guidelines, then states would be free to do whatever they want to do. There would be nothing to govern how govern like the seas, the airspaces, and the overall interaction. And then that would just bring chaos. So international law is basically responsible for helping states to interact with each other in an orderly fashion. And the term was first used by Jeremy Bentham in 1780. And this was basically an upgrade from the use of the term law of nations. And as I said before, there's private and public international law. Private international law was first used in 1834 by Joseph Story, and it covers the rules applied to a domestic court, which is confronted with a claim concerning a foreign element. So in private international law, you may find that, say, for example, in Jamaica, you have a US national in Jamaica, and you also have somebody from Germany. And there was an incident between these persons. What private international law does, it outlines how these states would move forward, because you have three persons from three different states. So which state is going to take up the matter, whether it is a criminal matter or anything like that, which state is going to hear the case or something like that. So that is what private international law is about. And that's basically it for the nature. Well, no. So the importance of public international law, as I said, the rules are important because they are created primarily by states and for their purposes, or as a means of facilitating the function of organizations of which they are members. So private international law is important because it was created by states for states. There are also questions on the legality of international law. So there are two main claims. There are those who say that international law isn't law, and those who dispute the legal nature of international law. So the supporters of the legality of international law, their argument is on the basis of one, state recognition. So members of the international community, they recognize that there exists a body of rules binding upon them as law. There's also state practice. So international law is practiced on a daily basis in the governmental organizations of the states, the courts, and international organizations. You also have the states. They're one of the most important subjects of public international law, or one of the most important subjects in international relations altogether. And these states, they do not claim that they're above the law or that international law does not apply to them. And the overwhelming majority of international legal rules are considerably obeyed. So when persons are saying that international law is not really law, those who are opposing this, they're saying it is actually law because states recognize it, states practice it, they're the ones who created it, and they obey the rules. And those who dispute whether international law is legal, like does it have that authority, they're talking about the lack of institution. So they're saying that there's no global government, or there's no global court that has the authority to prosecute states or to bring up states on any matter that they find that is in contravention with international rules. So it says that there's lack of institution, and the General Assembly of the UN is not such a body, and it was never intended to be that global institution. So the other one is that, as I said before, the deficiency of a court of international law. So they're saying that international law is not really legal because there's no court to govern the behavior of states. There's also the argument of the inadequacy of sanctions. So basically what this is saying is that states really, there's, as it said before, there's no court that can bring cases against the states. There's no global court. And so there's really no institution to apply the sanctions to these states. And the enforcement mechanisms on the international level, their argument is that even though there are these rules and regulations, there's really nobody or any institution to say that this is what you're supposed to do, and to ensure that they're actually doing it, because states have their sovereign rights and they have that right to govern their own relations. So those are the arguments for the legality of international law. And the next one is going to be sources of international law. So if you have any questions at all about the nature or the scope of international law, you can go ahead. Oh, and if you don't have any questions, you can just type no or no questions. Okay, so I'm just going to assume that there are no questions. So the sources of international law. So in international law, the sources are listed in Article 38(1) A to D of the Statute of the International Court of Justice. And it states that the court whose function is to decide in accordance with the international law, such disputes are submitted to it shall, and A, it says international convention. So these are the sources. What I'm going to list are the sources of international law. So you have international convention with a general of particular established rules expressively recognized by contesting states. You have international custom, and that is evidenced by general practice. You have general principles of law, and you also have judicial decisions. So then, if we're faced with a dispute at the international level, we need to ask first if there's a treaty obligation relevant to the subject matter. And if there is a treaty, then that would be used. If there's no treaty obligation, then the custom is going to be used. If there are no treaty or custom, then we move down to the list, to the general principles, and if necessary, the judicial decisions. So for any given dispute, there's a hierarchy of sources in international law. And normally a dispute between states, if there's a treaty or a convention, as I said before, on the particular point, then that will prevail. And if the treaty rule is different from the customary international law, this is so because in most cases, the treaty will be more specific than the rules of customary international law. However, in some cases, a rule in a treaty may fall into disuse with the passage of time, which is constituted. So if this occurs, the rule in the treaty may fall below the rule of customary international law. And that is just one of those times where you would use customs instead of the treaty to deal with the dispute. So treaties are central features of international relations, and they govern all aspects of the interstate relations, and they reflect the will of states. So a treaty cannot be binding on a particular state unless it was expressively consented to. So states have to they have to sign the treaties. They don't necessarily have to ratify the treaties, but as long as they it is at that point that they become legally binding to them. So Article 38.1 mentions international conventions, and whether general or particular, these are also a source of international law. And for the purpose of international law, the term convention is synonymous with the treaty, pact, agreement, memorandum of understanding, and so on. So the distinction between general and particular convention, so-called lawmaking treaty and the contractual treaty. So a lawmaking treaty is one which generates rules for future conduct of the party, and which by its terms and number of states party to it may become a part of customary international law. And a contractual treaty is more in the nature of a contract between the individuals or the individual states, and it sets out the rights and duties of a limited number of states. So the lawmaking treaty, it basically governs everybody. It sets out general rules. And the contractual treaty now is between two states or among three states and so on. And an example of lawmaking treaty, you have like the 1961 Vienna Convention, you have the Kyoto Protocol. Examples of contractual treaty, you have NAFTA, you have shipwright agreements. I'm not sure if you all know about shipwright agreement, but you can just look that up. It's basically an agreement between Caribbean states and the US in terms of anti-narcotics regimes. So looking at customs as a source of international law. So in asserting whether customary rule exists, it is important to determine whether state practice on the issue is uniform. And if a state practice on a particular issue shows no uniformity or consistency, it cannot be said that general custom has developed. So in order to use customary international law to settle a dispute or to analyze a certain dispute, you have to look at whether it is practiced by, how many states it is practiced by, and the consistency by which it is practiced. And the leading case in this is the asylum case, and that is between Colombia and Peru, 1950. In the interest of time, I won't be really going into the cases, but you can just look at the asylum case and know that you can use that as an argument to support, or use that as supporting evidence for when you're talking about or if you're talking about customs as a source of international law. Okay, so looking at the general principles. Yeah, so looking at the general principles, so the third source of international law in Article 38.1 of the statute of the ICJ is a general principles of international law, and it is represented by civilized nations. So as I mentioned before, if there's no treaty or there are no customs, then you move down to the general principles. And so the ICJ is directed to apply general principles to fill in the gaps in the law if there are no treaty or customs. And there's some uncertainty considering the precise meaning of Article 39.1. In particular, the questions usually range from, does it mean general principles of international law or general principles of national law? And basically, the better view is that it may mean both sets of general principles. So with respect to general principles of international law, the Permanent Court of International Justice stated in the Charzo factory case in 1928 that the rule that a breach of an engagement involved a duty to make preparation is a principle of international law. Likewise, in the Eastern Karelia in 1923 case, and the court referred to the independence of states as a fundamental principle of international law. So in international law, it is important to always remember that all states, they have their sovereign rights. They are independent because only independent states are, recognized. So they have that independence and that sovereignty to make their own decisions and deal with their own disputes. With regards to judicial decisions, so in the case of judicial decisions, the work of learned writers is a subsidiary source of international law. And as you can see, it is the last one. So treaties, customs, general principles, they would all take precedence over judicial decisions. And these judicial decisions are basically the writings of authors, of learned judges, and so on. So it's basically, judicial decisions basically talks about the way how judges ruled on other cases, and they basically use those as guidelines for the case at hand. And that's kind of it for the sources of international law. One thing, it is always important to remember that there's a hierarchy and you have to follow that in order to analyze certain disputes. Are there any questions about the sources of international law? Again, if you have questions, you can just open your mic or type in the chat. If you have no questions, just say no questions. Okay, no questions, I guess. All right, so moving on to use of force. So use of force is covered in Article 2.4 of the Charter of the United Nations. And I'm going to read the article, and then we're going to analyze it based on the different parts. So according to Article 2.4, there's a provision on the use of force, and it says that all members of the United Nations shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. So there are several aspects to consider. First, a prohibition is addressed to all members of the United Nations and to any country in the world. So the question therefore is, does that mean that, since it says to all members of the United Nations, the question is, does that mean those states who are not members of the United Nations, are they exempted? The answer is no. And that is because Article 2.4 is customary international law. And again, we remember customary international law, you have to analyze it based on uniformity and consistency. The other consideration is the reference to international relations. And that is meant to clarify that the provision does not prevent the use of force by states in their internal relations. So if a government has a riot or a rebellion within their territory, that has nothing to do with international law. While you might find that states, other states within the international arena might want to intervene, or they may take certain actions to influence the behavior of the internal matters of that state. In essence, whatever happens within the internal areas of the state does not have anything to do with international law in itself. The other consideration, it should be noted that Article 2.4 prohibits the threat and the use of force. And a threat is made when one state declares its intention to attack another state, or when it takes actions which may clearly be interpreted as preparation for an attack. And it may be difficult to determine when a threat is actually made. For example, when Iraqi forces were amassed along the Kuwait border in 1994, this was viewed as a threat. And you might have, where threats are concerned, you might have states acting up when there was actually nothing to be worried about. So that there are many questions where the threat of force is concerned. Also, the term force is clearly meant to encompass armed force. And so there are questions of whether or not it includes economic sanctions and so on, because not only military force can be considered as force. So you will find that the developing states, or like the third world countries, they'll say that yes, economic sanctions are considered as force, and you'll find the developed states saying that economic sanctions are not considered force. And you can understand that because the developed states, they use these things, their economic leverage and their political leverage, to influence the behavior of the smaller or the developing states. And so with the general recognition of economic factors or economic sanctions as force, you'll find that they'll be really breaking international law. And so since they don't want to have that kind of reputation, they're going to always deny that, or going to always say that economic sanctions are not considered as force. There's also the question of the significance between territorial integrity and political independence. So on one reading of Article 2.4, determined to place a limit on the prohibition so that a state may use force in its international relations as long as it does not violate the territorial integrity or the political independence of the state which is attacked. So this was supported by Bowitt, and it said that a state's territorial integrity is violated only when the state is annexed or permanently occupied or controlled. So the territorial integrity, for example, if Jamaica was supposed to invade or take over the entire US, then that would be a violation of territorial integrity. Where political independence is concerned, political independence is only jeopardized when the attack would result in the sovereignty of the state. So if the US were to intervene in the matters of the Jamaican government or the state, then that would be an infringement on the political independence, because the Jamaican state would be deprived of that right to determine their internal relations. And the supporting cases under this would be like the Carrefour Channel case, and that is between UK and Albania in 1949. So that is very important to remember. Sorry about that, there was something passing. Okay, so that is important to remember, and you can just read up on that. So there are some exceptions to the prohibition on the use of force, and it can be found in Article 51 of the UN Charter. And it says that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. So what this article is saying is that the UN Charter does not prohibit a state from taking actions to defend itself if it was attacked by another state. And they can go on and defend themselves, but the matter should be reported to the Security Council, and they can continue to defend themselves until the Security Council decides on a way forward. And the leading case here again is the the 1945 Caroline case or the Caroline incident, and you can also read up on that. As I said in the article, it also spoke about collective self-defense. And so it is important to look at this in the sense that states can defend themselves or, okay, so using examples, Jamaica, all the countries within CARICOM, right? So all the countries within CARICOM, say one of the countries were attacked by an outside state, by a state that is not within CARICOM, then at that point, all the countries within CARICOM, they would have the right to defend that state as an ally. However, collective self-defense, where it doesn't apply, is where a state just randomly sees that another state is having difficulty maybe with a neighboring state or is just being attacked by another state and just intervene. At that point, collective self-defense does not apply. And you can look at the Nicaragua case for this instance. There are also exceptions to the use of force that is not included. It's just something that they've always held on to, but is not really customary international law. And so that's humanitarian intervention. And humanitarian intervention is different from the protection or intervention that is supposed to protect the nationals of the state that is intervening. So humanitarian intervention comes about when an outside state sees what is happening within the state, the particular state, and wants to intervene out of concern for the human rights of the citizens. And that is different from a state having their own citizens within another state. Okay, I realize that this can get confusing. So using examples again, the US has their citizens in Jamaica. They find that they are threatened for one reason or another. Maybe there is internal riots and so on, and somehow they, whether perceived or real, their citizens are in danger. At that point, the US, they can intervene under the right or the need to protect their citizens. That is not humanitarian intervention. Humanitarian intervention is where the US would see that there are some human rights abuses within Jamaica that are happening to Jamaicans. And that at that point, as an outside state, then the United States would intervene in order to help the Jamaicans that are being affected. That is humanitarian intervention. And it's important to note the difference between both, because it can get confusing. And that is one of the exceptions to the use of force. It's not really an exception that is within the charter, but some states have recognized it as an exception. The final exception to the use of force is intervention by invitation. And this is where it is a controversial exception, I must say. So a number of states appear to support this exception to Article 2.4. And it can be noticed when you look at the Soviet intervention in Hungary in 1956, Soviet intervention in Afghanistan in 1978, and so on. So an intervention by invitation happens when an existing government seeks the assistance of another state to quell an uprising or a civil war by means of military force. So in intervention by invitation, using Jamaica and the US again, so the Jamaican government can invite the US government to come and intervene and to quell whatever internal dispute or internal uproar that is happening within Jamaica. That is intervention by invitation. But it has been criticized because there might be issues arising from that, where the state that was invited, they refuse to leave, or sometimes when the state that is having the issue, sometimes it is difficult to say who the legitimate government is. And so you might have a group of persons who are not really the legitimate government asking the state or the US to intervene within the matters of the state. So the issues arising from that, states might not want to leave when they are asked to intervene because they just feel like the matter is not finished, or there's more to be done, or they're not really invited by the legitimate government. So that's basically it for use of force. If you have any questions, you can go ahead or type it in the chat. Okay, so moving on to the subjects of international law. So a subject of international law is an entity capable of possessing rights and duties under international law. And states are the main examples of international persons or international subjects. And in the past, it was argued that only states could be international persons, but today you have entities that are recognized as international persons. For example, the United Nations to an extent, and other international organizations. So under the Montevideo 1933 Convention, the state, when recognized as a person, or if it should be recognized as a person, it must have certain features. And these features include, it must have a permanent population, it must have a defined territory, it must have a government, and it must have the capacity to enter into relations with other states. So where population is concerned, there's neither a lower nor an upper limit for the population of the state. So it could range from 1 to 10 persons. There's really nothing to say that, okay, in order to be recognized as a state or as an international person, you have to have, say, 50 persons within your state. Similarly, in determining whether an entity satisfies the criteria for statehood, the size is irrelevant. So there's no specific size to say that a state must be measuring, I don't know, whatever states are measured in. So they must be measuring a certain size in order for them to be recognized as a legal person. It needs only to establish that there's a defined territory under the jurisdiction of the state. And it is important to note that the requirement of the defined territory is not usually firmly applied. So even if some of the entities' borders are in dispute, this will not prevent them from being recognized as an international person or recognized as a state. And where capacity is concerned, most states are now members of the United Nations, and membership in the United Nations presupposes statehood. So their capacity to enter into relations with other states, as long as you're a part of the United Nations, you know that you are recognized as a state, and at that point you can indeed engage in relations with other states. So international organizations are now regarded as international legal persons for certain purposes. And you can look at the reparations case. Sorry about that. You can look at the reparations case of 1949, where the US was, not the US, the UN, the United Nations, was recognized as a legal person to bring that dispute in front of the competent body. You also have individuals. So at first, only states were recognized as legal persons in the international system, but now individuals are also being recognized. Well, individuals are still not subjects of international law. However, you have organizations like the ICJ, it does not hear cases brought by individuals or by companies. It only hears cases by states. But you have like the Court of Justice of the European Communities. It allows individuals to bring cases before it, and tribunals set up by the ICC for the settlement of industrial disputes. Those also allow individuals to bring cases, but individuals in themselves are still not subjects of international law. And yeah, that's it for the subjects of international law. Any questions? Okay, so title to territory. So starting in the late 15th and early 16th century, the European powers, they sought to justify their expansion to various parts of the world, and they used, is somebody trying to say something? Okay, so they used doctrines in order to justify their expansion. And so under international law, a state was said to derive title of territories in the following ways. So you have secession, occupation, prescription, conquest, and operations of nature or accretion. So for secession or cession, this involves a transfer of territory from one state to another, and this is usually done by a treaty. For example, following the Napoleon War, the Treaty of Vienna in 1815 resulted in the transfer of Norway from Danish to Sweden sovereignty. So with cession, one state, they basically agree to, through a treaty, they basically agree to transfer territory from one state to another. And the case under this that you have to pay attention to is the Island of Palma's case between the Netherlands and the US of 1898. The other one is occupation. So under traditional law, occupation is an original mode of acquisition under which a state acquires sovereignty over what is called terra nullius. And it is a piece of territory. So it's a piece of territory not under the sovereignty of any state. And this is not used in contemporary international relations because majority, if not all, of the area within the world on Earth is already occupied as a state or some form of territory within a state's sovereignty. So occupation is not really used now, but it is where like a state, they just go and just take a piece of property that really does not belong to anybody or did not belong to anybody. Prescription, this is the other way that title can be acquired for territory. So prescription, and this is similar to the concept of the title founded on long and peaceful possession in municipal law. So where prescription is concerned, it must show two things. In order for territory to be acquired through prescription, the state must show that it held the territory in question for a long time, and that the state which previously held the title has implied that or given agreement to change over the sovereignty of the new state. So in other words, if a particular state had a piece of property or it had wherever it had under its sovereignty, and then another state, say state B comes and state B occupies that area, is there for a long time, say over 50 years or so, there's no specific amount of years, but say over 50 years, and state A is not complaining that state B has acquired its property, state A does not show any form of interest in that piece of property, then state B can claim the title to this territory. So in order for prescription to not be allowed, the state A would have to protest that it had this property under its sovereignty and it was actually interested in keeping it, or it's still interested in keeping it. So the state basically has to safeguard its property. So if they just leave it like that, they don't show any interest in it, they don't show any form of like plans to do anything with it, then the state can come and occupy it through prescription. The other one is conquest. So under traditional law, cession imposed by force or conquest would be legitimate and would lead to the valid acquisition of title. However, this position is now untenable because current international law prohibits the use of force in international relations. So conquest is like where states would just, or for example, where you had the British or the Spanish, they just came and they took over property and they took over state and so on. So, and it would then become their own. So through conquest, that was traditional. But since in contemporary international relations, as we talked about use of force, there's a prohibition on the use of force. So an outside state cannot just come and say, hey, this property is now mine, or the state and whatever is within these borders is now mine. So because that would be classified as use of force. So conquest cannot be used within contemporary international relations, but that's basically what it is about. And then we have operations of nature or accretion. So acquisition of territory by operations of nature is of little legal interest because it gives rise to a few problems. A state has exclusive right to addition to its territory by way of silting or other deposits, or to island forming within the territorial waters. So this one is not really important to contemporary international relations, but it's basically where through nature. So say Jamaica has a certain amount of property, but then maybe through natural causes, maybe volcanoes, and just whatever forces that cause different pieces of land to just come together at some point in time, then at that point, it could be claimed as Jamaica's property and under Jamaica's sovereignty. And so the important cases under this would be like the Western Sahara case. You'd also look at the Temple case. And yeah, that's basically it for this part, for title to territory. Does anybody have any questions? The first case, you have the Temple case, the Western Sahara case. So I mentioned the Western Sahara case, and you have the Temple case. No problem. So moving on to human rights. So by the end of World War II, the developed powers, they were basically startled by the death camps in Eastern Europe, and they came together to produce a UN Charter. And they stipulated in Article 1.4 that the principal role of the Charter is to achieve international cooperation in promoting and ensuring respect for human rights and fundamental freedom for all without discrimination to race, sex, language, religion, and so on. So Article 55 and 56 of the UN Charter confirms that the United Nations should promote human rights and gives an idea of human rights in concrete forms. So the UN General Assembly issued the United Nations Declaration of Human Rights in 1948. And the UDHR, as we'll be referring to it as from now on, it was a UN General Assembly resolution. And if you recall, with UN General Assembly resolutions, they are merely resolutions, they're not legally binding on the states. So that was one of the issues with the 1948 Universal Declaration of Human Rights. So the UDHR, it sets out some rights, and so you have the right to life, liberty, and security of persons, no slavery or servitude, equality before the law, right to nationality, right to thought, right to own property, and so on. So there's a whole list of rights. So as a UN General Assembly resolution, as I said before, the UDHR was not legally binding. So for this reason, the United Nations, it sought to find ways in which the provisions of the declaration could be given legal form or could be made binding. And so this, they solved, or quote unquote solved, this issue with two ways. So most countries which obtained their independence after 1948, they have included human rights provisions in their constitution. So they have ratified it. And in the case of Jamaica, prior to 2011, these rights were incorporated in Chapter 3 of the Jamaican Constitution. So these rights were incorporated in Chapter 3 of the Jamaican Constitution. No, there's no Chapter 3. There's just the Charter of Fundamental Rights and Freedoms. So the second way in which the UDHR is given legal form is through the formation of the International Covenant on Civil and Political Rights, the ICCPR. So these are two major treaties. So you have the ICCPR and the International Covenant on Economic, Social, and Cultural Rights, that's the ICESCR. So the problem was that the UDHR, it set out the different rights, or just provided a general rules and guidelines on how states should approach human rights. But the issue was that it was not legally binding. So it was basically just there as guidelines. States didn't really have to follow it. So what they aimed to do was to make it legally binding. And the way to do that was to create treaties. I remember we mentioned before that treaties are legally binding once they are signed and ratified. So they created treaties, and these treaties, they corrected the non-binding effect of the UDHR. With the ICCPR, that's the International Covenant on Civil and Political Rights, those are often referred to as first generation human rights. And the ICESCR, those are referred to as second generation human rights. First generation human rights, they talk about, as it says, your civil and political rights. So your political freedom, how the state, how you interact with the state, and how the state makes provisions for you. The second generation human rights, now those have to deal with it, like your right to education, right to work, and so on. So the ICCPR, that's the International Covenant on Civil and Political Rights, it has two options. You have the first option and the second option. And the first option is where the state grants the rights of an appeal to its nationals, to the United Nations Committee. So states can, individuals within the states, they can bring human rights concerns or issues or claims to the United Nations Committee under the first protocol. So if the state signed on to the first protocol, then its nationals are allowed to do that. The second optional protocol now is concerned exclusively with the death penalty. And under the second optional protocol, it stipulates that the parties, they basically put measures in place to abolish the death penalty altogether. Again, if the states are not signed on to the second optional protocol, then this prohibition or this requirement for them to abolish the death penalty does not apply. And it must be noted that Jamaica is not a signatory to the second optional protocol, as well as many other states within the Commonwealth Caribbean. So where human rights are concerned, there are other regional treaties, and these include the European Conventions on Human Rights, you have the Inter-American Convention on Human Rights, the African Charter on Human Rights, and there are a number of treaties which specifically prohibit the death penalty. As I mentioned before, you have the second optional protocol to the ICCPR, you have the protocol to the European Convention on Human Rights, and the protocol to the American Convention on Human Rights. So Jamaica is not a party of any of these treaties, nor is the Bahamas, Trinidad and Tobago, Guyana, and so on. Therefore, there's no clear treaty prohibition on the death penalty in the Anglophone Caribbean states. And there's also no customary international law prohibiting the death penalty. So remember, we said before, customary international law, in order for something to be seen as a custom, there must be consistency in its practice and uniformity in its practice. So even if, so since there are states that have not abolished the death penalty, there are still states who use the death penalty. We cannot say that there's a uniformity in the abolition of death penalty or there's consistency in the abolition of death penalty. And even if the death penalty were customary international law, then states like Jamaica could argue that it has been a persistent objector to that custom. And that is because from the onset, they have shown that they're adamant to keep it on the books. And even though it has not been used for quite some time now, they're adamant to keep it on the books. And the fact that the creation of the Charter of the Fundamental Rights and Freedoms, it included the death penalty and made provisions for that. That was what, in 2011, it shows that Jamaica continues to be an objector to the abolition of the death penalty. So Article 6 of the ICCPR provides some guidance on the death penalty. It highlights the right to life and that there should be no arbitrary deprivation of life. It states that in countries which have not abolished the death penalty, the sentence of death may be employed for the most serious crimes in accordance with the law. It also states that the death penalty may be carried out only pursuant to a final judgment rendered by a competent court, and it goes further to state that persons sentenced have the right to seek pardon or a commutation of that sentence. Article 6 provides that the death penalty may not be applied to persons below the age of 18 or to pregnant women. So in Jamaica's case, women are not subjected to the death penalty. And Article 7, of the ICCPR addresses the question of cruel and inhumane treatment. And issues concerning cruel and inhumane treatment were at the center of the judicial decisions of the Committee of the Privy Council on the case of Pratt and Morgan. So in the Pratt and Morgan case, where they were brought to the gallows or the room next to the gallows about 3 times, and they were there for over 5 years, the JCPC, that's the Judicial Committee of the Privy Council, it ruled that this was cruel and inhumane, and for that reason, they placed basically a 5-year time limit on the death penalty. So at that time, they said that if the death penalty was given as the punishment for the offense, then it would have to be carried out within 5 years. However, that would be an issue because according to Article 6 of the ICCPR, it says that the person sentenced, they have the right to seek pardon. And if they have the right to seek pardon, then it means that they could appeal, and they can appeal to outside the final court, the final appellate court, and that's a JCPC, and that takes quite some time. So by the time they're supposed to go through all the domestic legal procedures and to get leave to go to the JCPC, that would be over 5 years. So you can see where if that were maintained, then the death penalty would not be allowed to be carried out at all, because that would take up a lot of time. And it's not like the it's not like this, the individuals or the accused or the convicted, they can be exempted from having that right to pardon or having that right to appeal their case. However, this is not the case now, because when the Charter of Fundamental Rights and Freedoms was created in 2011, or was included in the Constitution in 2011, they did away with this 5-year term. So now, even if it takes beyond 5 years for the accused or the convicted to appeal and get their final decision on their case, then the death penalty can still be carried out. And yeah, that's it for human rights. If you have any questions, you can go ahead, open your mic or type it in the chat. Okay, so the final topic is going to be diplomatic immunity. And diplomatic immunity basically talks about states having or not having the right to take legal actions against individuals who are within their borders for diplomatic reasons. So what diplomatic immunity ensures is that if, again, using examples, so if, well, I'm not going to use Jamaica at this time again. So if, say, somebody from Barbados, maybe an ambassador or somebody who is working as or on behalf of the Barbadian government, goes to the United Kingdom, and what diplomatic immunity seeks to ensure is that whatever rules or laws within the United Kingdom, this does not prevent the Barbadian individuals from carrying out its functions, or whatever the person's duty is, their rules or their laws does not prevent them from carrying out that. So state immunity, you have state immunity, and you also have jurisdictional immunities. So to maintain the sovereign equality of states and to facilitate the conduct of international relations, that is what jurisdictional immunity is about. So certain rules of state conducts, they have been developed to limit a state's exercise of jurisdiction in specific cases, even within their own territories. So state immunity, it flows naturally from the principle of sovereign equality. So no state should be able to subject another state to its judicial processes. So when foreign states or state representatives gain a right or access to another territory, it is implied that they are granted immunity from the host state's judicial processes. So this right, it is not granted, it is an obligation. So as long as you're going to that state to do some form of work on behalf of the government, it is an obligation. You do not have to wait until that particular government grants you immunity. It ensures that states preserve the independence and that the foreign officials are not affected by other countries' enforcement jurisdictions while carrying out their mandate. So the rules where immunity is concerned, so the general principles of state immunity. So jurisdictional immunities convention in Article 5, it states that states enjoy immunity from the jurisdiction of the courts of other states, and this immunity extends to state property in a foreign state. So if the state has some form of property within the state that they're sending their diplomat or their ambassador to, then that property also is not subjected to the laws or the rules of the receiving state. States reserve the right to waive such immunity through treaty, contract, or expressly before the court, and it may also be implied through state conduct, and it must be clear or unambiguous. So even though this immunity is not granted, states still have the right to they still have the right to waive it. So state immunity and human rights and humanitarian law. So the creation of international criminal jurisdiction means individuals can be condemned by the international community and tried for international criminal conduct, and should such individuals be held accountable in the domestic court as well. So state immunity would be restricted for certain crimes. And if you recall the Pinochet case, so this case, it affirmed state immunity, and the only loophole may be if criminal pursuits are on the basis of ratione personae after the representative leaves the office. So as long as the individual is acting on behalf of the state, there can be no legal like there can be no legal cases involving that person, because at that point it would prevent them from carrying out the duties that they are asked to carry out on behalf of their state. So what entities of the state are entitled to immunity? So you have heads of state and members of the government. You have organs of the government, such as the ministries, the agencies, the departments. You have state officials, representative agents, and the servants acting in these capacities. And a court cannot order a foreign state to take action. It cannot order action against the property of a foreign state. So that is also a part of state immunity. So where the 1961 Vienna Convention on Diplomatic Relations is concerned, it addresses the rights and the obligations of states vis-a-vis permanent exchange of diplomatic personnel. And it also talks about the establishment of diplomatic missions. And you have other conventions that also deal with diplomatic relations, such as the Vienna Convention on Consular Relations. You have the Convention on the Privileges and Immunities of the United Nations. You also have the Convention on Special Missions. So Article 3 of the Vienna Convention outlines the functions of the diplomatic missions as representation of the sending state. So the diplomatic missions, the individual is going to act as a representation of the sending state. They're acting to protect the interest of the sending state and its nationals. They are going to negotiate, or they're going to negotiate with the government of the receiving state, or ascertain some form of information on the conditions or the development of the receiving state. So under diplomatic immunities, so the individual has immunity from any form of interference, arrest, or detention whatsoever, as well as the duty of protection by the host state. And the premises of the mission, its archives, its documents, the diplomatic bag, and so on, it also is inviolable. And inviolable means that, again, there should be no interference, no arrest, no detention, or anything. The receiving state must protect the premises of the mission against intrusion, damage, or breaches of peace. No agents of the receiving state may enter the premises without the express consent of the head of the mission. It doesn't matter what the circumstance is, there should be no entrance without permission. Inviolability of official communications also extends to the diplomatic courier and the diplomatic bag, as I mentioned before. Article 27.3 talks about the diplomatic bag, and it says that the diplomatic bag shall not be opened or detained, and that is a literal bag. The persons of diplomatic agents and their families are also inviolable, so they are not liable to any form of arrest or detention. And the state must protect them from attacks against their person, their freedom, or their integrity. It also applies to administrative and technical staff and their family. And inviolability must be respected regardless of the surrounding circumstances. So while the person is within the position or within that occupation, the inviolability applies to them. And they should be allowed to leave the state whether or not they committed an offense. So despite immunities, diplomats are under an obligation to respect the laws of the receiving state. So even though they have some amount of state immunity, immunity from the rules and the laws of the receiving state, they still have that obligation to respect the laws. So it doesn't mean that they should go out of their way to commit some offense just because they have state immunity. And where they do not have any respect for the laws of the receiving state, the whole state, it has the right to revoke their diplomatic status and basically just send him back to where he's coming from or where she's coming from. Where immunities from criminal jurisdiction is concerned, diplomatic agents are immune from all local criminal proceedings. They are immune from local civil and administrative jurisdiction, except in actions related to privately held property, estates, actions involving the diplomatic envoy, and so on. And sending states, they retain the criminal and civil jurisdiction over the diplomatic envoy. So, and so if an individual basically goes to another state and maybe committed an offense, they are not subjected to the laws of the receiving state. They are still under the jurisdiction of their sending state. So the sending state would decide what the actions are. And at that point, the sending state can decide if it's going to have the receiving state take over the matter or they are going to deal with the matter themselves. So they're also immune from taxes. So diplomatic missions are exempted from taxes on property. They're exempted from social security payments and so on. And yeah, so that's basically it for diplomatic immunities. If there are any questions, again, you can just go ahead or you can type it in the chat. No questions? My notes, they're not in soft copy, so it's not something that I can send like that. It's hard copy. Okay, so if there are no questions, then that would be the end of the session. If you have any questions after this, then you can always direct it to who, I don't know. I was going to say Chanel, but she's not here. So I guess you can, or maybe Kimani. Anyways, guys, thanks for coming. And that's it.
All right. Yeah, you can add the page if you have any questions for Ashira. So Ashira, I see the thank yous being sent in the chat. So thank you so much for helping out the students today, and to the students as well. I really hope that you guys benefited from this. The session was recorded. Well, it's still being recorded, and it will be posted on YouTube at FSS. I'll type it in the chat, FSS Skill Media. So we're trying to post the sessions by tonight, but if not, you can definitely look out for them in the morning. All right. So I'll send it in the chat. So if you like to go over the session, if you like to go over something that was said that you missed or anything you want to clarify on, you can check that out. All right. So thank you all once again, and thank you again, Ashira, and do enjoy the rest of your night.